Welcome to the Society of Wetland Scientists webinar series. We are so glad that you could join us today. My name is Jason Tucker, and I am pleased to be the moderator for today's webinar. I am an environmental scientist for HDR, an engineering firm in Cincinnati, Ohio. As a member of the SWS webinar committee, I help coordinate professional short course certificates for each presentation. We are excited to share this SWS e-learning experience today for all to stay engaged virtually and earn continuing education credit. Today's lecture and topic will be a legal approach to designing a strategy for the improved management of wetlands in South Africa. It is my distinct pleasure to introduce our speaker today, Bramley Levine. Bramley is a PhD candidate at the University of the Western Cape studying law and wetlands resource management. A published researcher, a parliamentary report cited one of his articles addressing the issues of achieving wise use of wetlands in South Africa. Bramley lectures environmental law at the Cape Peninsula University of Technology in Cape Town, South Africa, and guest lectures on law and wetlands at various South African universities. He was recently invited by the Universidad Científica del Sur in Peru, and he was also a featured speaker at the 2023 SWS conference in Spokane, Washington last year. Bramley imagines what existing water management courses at higher education institutions will look like with the law and wetlands as a subject matter. Bramley is a committee member of the Western Cape Wetlands Forum, where he works with a fantastic group of scientists. Though not a scientist himself, he enjoys learning about the science of wetlands and not just from a perspective of law. When he is not teaching or researching, he enjoys training for marathons, including the Ultimate Human Race, which is an incredible 55-mile long race, which is also 89 kilometers. After he completes his PhD program, Bramley aims to focus on wetlands resource management education. So without further ado, welcome, Bramley.
Thank you so much for the introduction, Jason, and good evening. Oh, it's evening in South Africa. Good day to everyone joining this webinar. Let me just find the screen to share. Okay. Thank you all for joining. It's evening in South Africa, and in my mother language, you say goeienaand. So my presentation, as introduced by Jason, is a legal approach to design a strategy for the improved management of wetlands in South Africa. Oops, apologies. So the background to the study relates to the publication that we are losing wetlands 3 times faster than forests. And here to share some stats in South Africa, or the stats that we currently have, or the 2020 to 2021 stats, is that out of the 792 wetlands ecosystems, 65% have been identified as threatened and 48% as critically endangered. Now, South Africa is a party to the Ramsar Convention without having submitted any reservation. So the consequence is then that South Africa binds itself to all the articles so contained in this convention. The overall aim of the Ramsar Convention is to stem the progressive loss of wetlands now and in the future. And often when I read this provision of the Ramsar Convention, I always ask myself, we'll forever be in the now when we read it, and the future will always be somewhere in the distance. And my thinking is that the drafters and parties in 1971, when they gathered in Iran, my thinking is, did they think that this would be the future at that times now? And which is quite concerning, considering the rate at which we are losing wetlands. South Africa became a party to the Ramsar Convention, signed and ratified the convention in 1975. Now, just the way in which South African law is incorporated, we follow a holistic approach to incorporating international law, which means that instead of taking the Ramsar Convention as is and situating it somewhere and making direct reference to it, South Africa has incorporated these various provisions in a suite of laws. And this seemed to have been problematic. Many scholars in South Africa have highlighted the issue with the fragmented state in which our wetland law currently is. And it's not only a South African perspective, but globally as well. And the Ramsar Secretariat has mentioned in various of their publications that this uncoordinated way of regulating wetlands needs to stop, and we need to find ways, strategies, policies, pass legislation to overcome such uncoordinated and fragmentation. In this scenario, or for my research, I've designed a strategy that, because of the law and the tools that I use or material, the strategy is one in law and not one of morale or one of favor. Just an overview of what this study looks like. So on the left is the title. In the middle section, I rely on the rule of law, which as interpreted refers to us looking at international law, or for the study of international law, not only confined to the Ramsar Convention, but mostly to the Ramsar Convention, because we know that there are ancillary conventions and treaties, the SDGs, the Constitution of South Africa specifically, legislation, case law, as well as policies. And these are on an ad hoc basis categorized into hard and soft law provisions. And through the lens of three specific, or creating three specific lenses, the strategy will be designed, and we'll speak to each one of those throughout this presentation. The theory that, or the theoretical underpinning for this study, is the rule of law, because it's a legal approach, as opposed to many other approaches that can be adopted, and the wise use of wetlands as contained in Article 3.1 of the Ramsar Convention. Now, the rule of law, we say, is the practice of law through sources of law. In other words, it tells us how we as society, or it dictates to us how we should act. And the sources, as highlighted above, will be utilized here as well. The wise use of wetlands has been defined as the maintenance of an ecological character through an ecosystems approach within the context of sustainable development. Everard is one of the authors that was cited as contributing towards the factors, and this made it easy for this research in terms of identifying this typification of this theory, helped with the identification of strengthening this legal approach. Now, the contribution is at the intersection of these two theories. And just briefly, as I will go through it later on, one, it fills a gap in rehabilitation measures in South Africa. Two, we'll look at extraterritoriality and aspects relating to first-generation human rights. Three, the regulatory role of local government. And four, the rehabilitation measures, which is part two. Part one and part two is two separate publications in two parts, focusing on Canada, Uganda, and Kenya. And you'll see, if you are able to, on the far right side, there's an arrow running between the two squared blocks. And that was a surprise finding towards the end of another publication, where the one learned from the other, and this is an interconnection that that I'll demonstrate to you later, I think. So the methods employed, it's purely qualitative in nature, and the technique employed is doctrinal legal analysis, documentary analysis, content analysis, and thematic analysis. At times, different analyses are used for different publications. At times, it's just one or the other. The materials used are predominantly the resources or the sources of law. So it's the applicable international conventions, because at times we find ourselves in CITES or referring to the Biodiversity Convention or other conventions that's in line with the Ramsar Convention, South African Constitution, legislation, policies, and regulations, where the study lends itself to other jurisdictions or extraterritorial reference to those policies will be made. Case law, decided court decisions, journal articles, as well as the SDGs and Agenda 2063, which is the African agenda, the Africa we want. So the question is, why a strategy as opposed to then recommending a national policy or law? I also have to say up front that it has been published that the Department of Forestry, Fisheries and the Environment in South Africa is in the process of designing a national policy for wetlands resources. But the rationale for this is that strategies are specific and they are action orientated. And with all these laws or the plethora of laws that we have in existence, I find that it would be better to then have a strategy as opposed to creating brand new laws and rather amending them and tying them together, because the argument is that action is what we need. So therefore, I aim to, through the interpretation and application of the existing body of law, recommend this strategy. And where amendments are recommended, that they be implemented as such. Now we're getting into the specific approach followed in the study, which is the three lenses: the Sustainable Development Principles in South Africa, which stems from our National Environmental Management Act, a study on local government, one overview of the regulatory role of local government, as well as rehabilitation measures. Now, the first lens, which speaks about the Sustainable Development Principles, the two contributions relating to that. The first contribution, raising a point in Lemony based on Lemony's efficacy article, has been accepted for publication. The wading into debate has been published. But I want to draw your attention to something more exciting, because you're going to get bored of the law and legal jargon all the time. So I've included pictures of myself of significance in relation to me trying to be an overall scientist or wetland scientist, because often I've learned more the understanding how wetlands function and the services they provide and what to do actually inspired the writing of certain articles in application of the legal approach. So this picture is taken at the Western Cape Wetlands Forum's World Wetlands Day 2023, and it was at the Onrus peatland wetland. And I have on a voice note that I've asked my colleague, Shade Daniel, who is the chairperson of South African Wetland Society, to just share with us the science behind this wetlands. And she had the following to say. It's a voice note of my phone, so I'm hoping that it's clear.
So the picture being depicted is the Onrus wetland, which is actually a peatland, and it was discovered that it was a peatland after fires in the area had occurred, and post-fire processes and being on site, it then was discovered that it was actually a peatland. And this just showcases the resilience of these type of wetlands in the landscape, and it's so important to ensure that these systems are protected and rehabilitated and afforded the protection that it's needed so that it can continue being a system that allows for resilience within a community, as well as to continue to be a place of habitat and species diversity.
Thank you. That was Shade Daniel, our chairperson of South African Wetland Society. So heading into the first lens, what I have to say outright is that the Sustainable Development Principles in South Africa are binding on organs of state. And Klazewski, one of our environmental authors, advised that this can no longer only apply to organs of state, but beyond. And this becomes clearer by the day when we think of aspects relating to, for example, citizen science. Now, it's obligatory in nature. We have, at the time of the publication, we had 18 Sustainable Development Principles, but now we have 19. And the two that we will consider for purposes of the study is Section 24L and Section 24R of NEMA. You'll keep on hearing me say NEMA. NEMA is short for the National Environmental Management Act, which is our overall Environmental Management Act, or the Framework Act. So the Section 24L makes provision for the harmonization of legislation, policy, and action relating to the environment. And the four authors of the later contribution submits that Lemony's 2021 paper followed a narrow interpretation of what this specific provision means in light of wetlands resource management. In brief, he focused predominantly on the laws within South Africa and finding those gaps. However, in the raising a point in Lemony contribution, which was a task of three different law academics and a scientist working in the field, we've discovered that this interpretation, there's a broader interpretation that's needed. And this broader interpretation is supported by Chapter 6 of NEMA, Section 24N of the Principles of NEMA, Article 26 of the Ramsar Convention, as well as Agenda 2063. And the argument is that in addition to this justification, we say that it enhances what harmonization can mean for purposes of Section 24L, and how we've interpreted this enabling provision in light of wetland protection is that it follows a purposive approach to statutory interpretation. So that's the tool that we've used to interpret this particular provision. And here we have in bubble form, the justifications. Chapter 6 of NEMA makes provision for the international obligations and agreement that South Africa has with various other states within their region, across the continent. 2 is Agenda 2063, which is continent-wide. Article 26 of the Ramsar Convention speaks about the international responsibility that we have as a contracting party. And finally, within our own provision, Section 24N speaks about the global and environmental responsibility within our national interests. So in this, whilst drafting this paper, I then realized, but there's one other principle that's linking or attaching itself naturally to another. And you ask ourselves, so what is South Africa's national interest? And a definition is found in our framework documentation on South Africa's national interest and advancing the global agenda. It says the protection and promotion of national sovereignty, well-being, and prosperity of its citizens, and a better Africa and world. And therefore, this alludes to the fact that perhaps Lemony's site at that time was not broad enough or didn't encapsulate this specific interest that speaks to a better Africa and world. But what about wetlands? Wetlands is specifically itemized in the same framework, and the provision in that says that wetlands degradation is to be listed or is listed to be addressed in pursuance of the national interest, which brings us closer to the justification for the specific interpretation or a broader interpretation. So what's harmonization? Because again, we say that there's a limitation in the previous study, and harmonization in brief speaks about agreements, compatibility, common rules, creating subminimum. But the preferred form for purposes of the study was not about legislative similarities. We're not interested in that, because each state, whether they are contracting parties or parties to the convention, it means that they strive to bring about legislative complementary instead of it just being similar in nature. So a provision in South African law could be different to the provision in Namibia and Canada, who are contracting parties, but the effect or the consequence is the same. So keeping with that sovereignty and trying to, at the same time, build this relationship with other states and complying, we've chosen that particular view. So sorry, I just need to move that. So the purposive approach, why did we use this approach? Because it favors a constitutional interpretation. Why a constitutional interpretation, and why do we make reference to the Constitution? In South Africa, the Constitution is the highest law of the land, and all laws as well as policies, regulations, and action must be in line with the Constitution. And here I want to emphasize action, because the strategy that's designed in this study relates to action, operationalization. Section 24, and why specifically Section 24, it is known in South Africa as the Environmental Clause. Why not the Wetland Clause? Well, in other jurisdictions, for example, Uganda and Brazil, they have express provision made to wetlands in their constitution, where South Africa, we do not. But it doesn't mean that there's no protection, because environment must be read to include wetlands. Oops. Okay, so what did we find for leg 1? So Section 24A of the Constitution makes provision for environment that's not harmful to our health and well-being. How do we protect that within a legislative framework? Is that the requirement is that we need to pass reasonable legislative and other measures. Other measures have been interpreted by Justice Yaqub in the landmark case of Grootboom to be well-directed policies and programs. And here one could sneakingly say actions too, because that's what they translate to. And can this policy then only be limited to South Africa or South Africa's environment? Further, we found a case on the Nyamakazi versus the President of Botswana that says that a purposive approach to interpreting this provision in this way will lead us to beyond just what legal rules want. It speaks about the impact of future implications. And if we think back to what the Ramsar aims to achieve, and our sustainability is the future implication. So the way international law is usually viewed when incorporated in South Africa is in that direction. However, Section 24L in the contribution demonstrates that Section 24L aims to achieve that, right? So it actually reaches out into different jurisdictions. So in conclusion, what we found that was environment should not be read only as a natural environment, but also the built environment. And we've kind of shifted or added to the theory of wise use by stating that we now also have to consider, if environment speaks about the natural and the built environment, and it speaks about the health environment that's good for health and well-being, we've now taken into consideration, or the study also lends itself to persons with disability, which is something that the previous study has not focused on. So it shifts the green rights perspective into a more first-generation rights. It also brings about the interconnectivity between these various goals that we aim to achieve, and they are cited extensively in the contribution. The following principle is Section 24R. And what struck me about this in this specific provision was why in the entire Environmental Framework Act is it the only time that we see the word wetlands in NEMA. And that drew my attention. Again, not to say that it's not mentioned somewhere else. It can be defined under the word environment or water resources or water courses. Why is this specific principle drawing our attention and saying not only about wetlands, but also that a specific attention must be guided when it comes to the management and planning, as they are subject to significant human resources. And colleagues, this specific act is an act of 1998, just to give you some perspective. So again, we follow a purposive approach. And what we were interested in is, what does specific attention mean? What does management mean in light hereof? And what can we do if there's pressure on wetlands? Do we have the necessary tools to relieve wetlands from the specific pressure? And what we found is that before I go into the ecosystem regulatory discrimination, I just have to explain that integrated coastal management for coastal shores and estuaries have been listed in Section 24R. So what I'm saying in brief is that if we have a Coastal Management Act in South Africa that functions at national, provincial, and local government, why is there no push towards a Wetland Act? And this is where the welcoming of the National Wetlands framework or policy is introduced or thought of as a way of specificity into that enabling provision. So ecosystems regulatory discrimination, why? If we have the one, why do we not have for the other? So we came up with a term called ecosystem regulatory discrimination. And this specificity is further extended by the Ramsar Convention. How so? Ramsar Convention speaks about wetlands of international importance, other wetlands, and it has a hospital for wetlands in terms of the Montreal record. And South Africa had two of its wetlands of international importance that were listed under this record, and that was due to mining activities. What did management, when we interpreted through the interpretation, what did management mean, or what does it allude to? Now, in the publication, we look about the who must do what. And here we look at, the focus was on spheres, sectors, institutions, and human resources. We said we need all of these to fit succulently into what is specific. And what is not mentioned and only added on here post publication is indigenous knowledge, which is a critical aspect in wetlands resource management. We also found that there are adequate tools to remove the pressure of wetlands, but then other barriers, political will, socioeconomic needs, etc., could play a role in this specific sphere. We've also realized that forward planning and tools and data sharing is required in order for decision makers to make their decision. So to conclude, again, the intention of the legislature is to ensure the optimal management of wetlands. That's what our take home. The policy that's been introduced is a suitable vehicle for advancing the object of this particular section. And although there is a policy plan, we really need action. And if I could pick off the top of my head, just in Africa, we have Ghana, Uganda, and Kenya that has, in addition to the wetlands policy, also published a strategy. And this empirical data had shown that there is the success that came off these particular things. Some countries developed the policy first, then the strategy, or the strategy followed by a policy. Okay, so now we're venturing into the second lens, which is the role of local government through the lens of Article 3.1 of the Ramsar Convention. And this was a teaching done at the Nelson Mandela University to conservation students. I was guest teaching there for a week, and the presentation was limits the option for dialysis or transplant the kidneys of South Africa's landscape and the status quo. Why did this particular study interest me, or where did this idea come from? Environment in the Constitution is a shared functional competency of national and provincial government. Let me also take one step back and state that South Africa has three spheres of government: national, provincial, and local government. And the environment is a shared national and provincial competency. So where does this leave local government? And is it so that local government cannot make laws on this particular aspect? And before venturing into this, we found some publication and research that advised that that they in fact do play a critical role. And for purposes of wetlands resource management, what wetlands offer in terms of their services and their functioning, I found the following in the literature. This is just a short overview. The literature review is obviously somewhat longer. So in relation to food and water security, the authors advise that when it comes to communities' food and water securities, local government plays a critical role. In Harare, the author advised to, if we move to the left side, the city bylaws and planning policies. So the city laws and planning policies plays a critical role when it comes to wetlands resource management. Wetlands, local wetlands and regulations also plays a role when it comes to this intersection. And then to our right, we have the future vision must be set by local wetlands, and how they set this vision and mission will venture into South Africa's pathway in a bit. And then lastly, a tool that has been developed by the Ramsar Secretariat is the Wetland City Accreditation System, which is also almost like a nudge into getting local government, in my opinion, local government to not only comply, but to also bolster their efforts in light of wetlands resources management. In South Africa, one of our esteemed scholars in local government and environment submitted that local government in South Africa is the sphere of government that is closest to the people. And again, when we get back to the provision of the Constitution, Section 153A says that we have to give priority to the basic needs of the community. What that means is that there's a legally valid and enforceable environmentally relevant expectation on the part of right holders. And who are these right holders? It is the exact community that we have close, or we allude to local government having close relationship with. Now, when I read Article 3.1, I promise you I've been reading it for I don't know how many years. Something struck me. And the reason why I went to this particular article, so in international law, we sign and ratify our law into our domestic law. And now I want to see what role does government play, but local government, but specifically through Article 3.1 of the Ramsar Convention, because as a party, we must, it's obligatory, the language says it starts, the contracting party shall, which is a hard obligation, shall promote the conservation of the wetlands included in the list. And the list here to the wetland, that know is wetlands of international importance, and as far as possible, the wise use of wetlands in their territory. There's a bit of an issue with after the Harvard comma with as far as possible, the wise use of wetlands in the territory. But that's not discussed in the article. That is for later work. So Article 3.1, so what I've done is I've split the obligation up into two. So we now want to ascertain whether local government in South Africa plays a role in wetlands of international importance and all other wetlands. Now, again, this role is not one of morale or favor. This role is a regulatory role, which means it's within the confines of the law. So the techniques that were employed here is the documentary analysis of wise use, because we now need to understand what wise use is about. So we keep on speaking about wise use. What does it mean? And what does it mean within this context? So wise use is the integration of land, water, and living resources within sustainable development. And what interests me then is logic dictates that now I need to see what the role of local government is in terms of land use and planning in South Africa, what their role is in terms of water resources management and living resources management, and then tying it together in an integrated way. So these were the three themes: land, water, and living resources, and also some of the legislation, not all of it, because some of the legislation, for example, the local government legislation alluding to finances is not considered here, but it's definitely something that plays a role, as we'll see in a bit. So this is the set of legislation, the Local Governmental Municipal Systems Act. Here we focused on municipal planning, spatial development framework, and SPLUMA, which is the Land Use Management Act. Please excuse the acronyms if I go through it as is without any explanation. I have to apologize. Water, here we look at the World Heritage Sites, the Integrated Coastal Management Act, and this should remind you of something we discussed earlier, and the Protected Areas Act. For living resources, it's the Biodiversity Act and the Agricultural Resources Act. And I just want to comment that the Agricultural Resources Act is pre-1975, when before South Africa signed or became party to the Ramsar Convention. Now, just an overview, and the contribution fills a greater gap than what's here. So I just chose a couple of these provisions that relates to land. Firstly, what's ironic is that there's a provision in the Act that says local government must progressively realize fundamental rights in Section 24, which is ironic considering that it has no environmental functioning per se in the Constitution. And so then we move around, speaking about vision and mission of the municipality, looking at what the integrated development plan is, because the integrated development plan is actually a legal tool. It's not just any other plan. It's a forward-thinking plan of 5 years. And with SDF and land use planning, we look here at the zoning of land. So in some would say that there is a critical role that they play when it comes to specifically land use management. Next up is water, and there's one particular aspect I need to highlight here. So we've heard of the Integrated Coastal Management Act that functions on all three levels of government. Here, the Integrated Coastal Management Act empowers local government to prepare and adopt a coastal management program. In addition to that, they may then pass bylaws to implement that specific coastal management program. The Act is also flexible that it allows not only for them to draft this plan or make the bylaws, to also incorporate it into their IDP. And here again, if we go back to the regulatory discriminatory regulation or ecosystem regulatory discrimination and the functions here, this is water too, and it relates to water. They also play an active role in protective areas. The role is long, and also access to water. And here, I do not want us to think of access to water in the ordinary sense of the word, but also as alternative, as an alternative use. And that's the summary for what water is, or their regulatory role. Living resources. Okay, so we have alignment with the National Biodiversity Framework, conservation of agricultural resources, and implementing protected lists of ecosystems. Now, what is interesting here is that there's one particular tool in all of this that draws these three aspects together, which is the Integrated Development Plan. And as much as this is a legal tool, once these provisions are or aspects or strategies or strategic areas are included in the IDP, they must be budgeted for, which means now there must be enough money to then spend on and take care of and promote those interests in the IDP. So what we conclude, one of the surprising, so not once have you heard me speaking about wetlands of international importance, because they are succulently aligned with the World Heritage Convention Act, the World Heritage Site, and as well as their role in the protected areas. There's also case studies of management plans within the Isamangaliso Wetland Park, which is part of the international wetland body. Their role in both scenarios are either inherent or they are delegated. So at times legislation will say national or provincial government may do A, B, C, or if they cannot, that power can then be delegated to the local government. I also want to say outwardly that local government is a sphere on its own. It's not a sister or a cousin or to national or provincial government, because often I get the feeling or understanding when speaking to officers is that that there's no respect for that specific sphere, but they stand on their own as a sphere. Now, what we've learned here is that this also benefits. So if we can prove this, it yields benefits for the city accreditation tool for Ramsar. And the city of Cape Town, which is the city where I live in, is the first city to have received this accreditation. The third lens, and again, just to wake you up from all the legal jargon, it also alludes to two aspects. But before we go into it, there is a picture on the left. And that was be at our National Wetlands Indaba, which is an annual Wetlands Indaba with cross-disciplinary scientists in wetlands resources management, very interesting group of people. And that on the floor, which I thought this was an Instagram ready moment, is known as a roly-poly. They call it roly-polies. And a roly-poly is the following. The voiceover is by Kate Snadden. She is our chairperson of the Western Cape Wetlands Forum, and she advises as follows. If I can just scroll through it. Kate says the following about our roly-polies.
The roly-polies in your photograph are also known as ecologs or sausages, and they are soft rehabilitation options often used on quite flat slopes. So they don't really work on steep slopes, but on flat slopes where there's a bit of water flowing across the landscape, usually as sheet flow, and the sausages or ecologs trap sediment and water and hopefully seeds on the landscape, and you get good reintroduction of local seeds, and you can also plant behind them.
And that was Kate's explanation of what that is. And it's really interesting to learn about these things. So back to the boring side, which is the boring but very important side, is the legal aspects. And before I even explain what these two legs are about, I actually need to explain the rationale behind this particular aspect. And I'd like to cite authors from South Africa, and they said the following, that the intention of wetland rehabilitation is always to benefit the environment as well as society through protection or improvement of wetlands ecosystems and goods and services they provide. I haven't once touched on the goods and services, but there are many. And my thinking was that if we look at aspirations, to protect sounds more proactive. We are doing it on a day-to-day. We are saving, we are trying to save. But then my thinking was, what about the reactive measures? What about those wetlands? What about the legislation relating to rehabilitation? So if we're saying that the proactive measures are, there's fragmentation, which leaves gaps and is problematic, what about the reactive provisions? And Elliott and Blackmore in 2019 also emphasized the need for us to focus on these gaps. Oops. So the techniques that we utilize here is situational analysis of a sample of the wetland protection or conservation legislation. And the sample includes these list of things. In the actual contribution, there's a table that spells out each of these pieces of legislation and also its description. On the following slide, I've taken the sum of the aspects, similarities, differences, and I've tabled that, and that too is in the contribution. So that is the sum of what we have in the first part of the publication. So rehabilitation as a standalone is there, rehabilitation, protection, management, restoration. And you're thinking, these are all words, and why do they matter? Unfortunately, they do matter. There was a recent case I read just 2 weeks ago about wetlands resource management and a judgment in favor of extending a golf course in an area that was perceived to have been a wetland. So the words matter because in this, just briefly, in this particular case, the presiding officer alluded to the legal definition of a wetland. And within those confines, they work to ascertain whether there was a wetland. And this is why words are important. This is why the law and legislation is important. So our aspirations need to be spot on. And this is another example of why it's important. This is the recent case in June 2024 by the Economic Freedom Fighters versus the Speaker of the National Assembly. This has nothing to do with wetlands, but it's the principle that stem from it that said that basic principles of the rule of law, and I've selected 3 out of, I think, 8, is that the law must be clear. It must be non-contradictory. It must be congruent with how officials enforce them. So if the law is not clear, is contradictory, is fragmented, it becomes problematic. Its enforcement becomes problematic. And what I also want to state, because when I looked at this, it actually came to me, the fact that the legislation on your right in that table has passed constitutional muster or is in line with the Constitution, that's great, right? It has to be. The problem is that the sum of this legislation is problematic, right? Because if we put them together for purposes of wetlands, it doesn't necessarily work. And that's why also the wetland policy as a vehicle is good, along with plausible strategies to implement them. Okay. So what have we found in this particular section of the work? That there's definitely gaps. And this could lead to far more worse consequences than proactive measures, because these are wetlands that's already in a state that's in need of rehabilitation. And I also want to say upfront that it's not that rehabilitation is not taking place in South Africa. we have the Working for Wetlands group that that works hard and tirelessly. Actually, in fact, at the roly-poly picture, I met some of these people, and what an interesting group of people and talented group of people that that works tirelessly to restore wetlands within South Africa. And again, we need to consolidate these so that it's congruent with the constitutional aspirations. And these aspirations are listed in the particular contribution. Just for example, the interrelationship between the environment and the right to life, right to equality, which is one of my topics of passion, specifically environmental justice, and the right to human dignity, which is obviously an overarching right to all other rights in our constitution, South Africa's constitution. This then led to part 2, which is based on the gaps in part 1. So how do we close them? We need a model objective for rehabilitation measures. And here, also selectively chosen with 3 jurisdictions, Canada, Uganda, and Kenya. And why they were chosen, or best practices were chosen from their regulatory framework, is that these countries are either unitary or federal or mixed. South Africa is a quasi-federal state, and therefore, this mix of jurisdictions and their laws helped in carving a pathway towards this model objective that we aim to achieve. Oh, conclusion. That means I'm almost getting to the end of my presentation. So South Africa's legislature must be intentional about ambition in law to create legal certainty. We absolutely need to create it. We need to split our aspirations. We need to say, this is what rehabilitation means. This is what restoration means. And this is how we're going to achieve it, or these are the tools that we need. Again, the work by the on-the-ground institutions is lauded, but clear direction is required in the law. Because if we get back to court or wherever else, it becomes problematic. And then also, what I also like to say outwardly is that this paper has been published prior to the publication of our now white paper on the conservation and sustainable use of South Africa's biodiversity. And I like the definitions or the recommendations of what it is in that more than what it is in the contribution already published. And there's definitely a split. And what's exciting is to see that with the policy, how that will be handled in that particular section. And I think, so for future direction, what I'm planning on doing post my study is definitely continuing with the teaching in wetlands. Hopefully, I'll be at to those of you who will be joining us in Taiwan for the Wetlands conference. There'll be a blank poster, which will be mine, and I'll be asking for contribution from various scholars, from various disciplines, to contribute towards my project that I aim to set up, which is the wetland teaching. I am currently teaching with Professor Ponte from Peru. We've been co-teaching on the specific aspect on a voluntary basis. Then also the intersections between citizen science and the law is also an interesting aspect that stems throughout the research. Then also non-state parties and customary international law. So if you allow me just for 1 minute, is that these countries are usually derided for their efforts. Because you are not a party to the convention, these efforts are derided. But we can actually glean lessons. There are 2 African countries that we can glean lessons from that's not parties. So maybe also focusing on customary international law, which is then practice, usus, and opinio juris that has been crystallized into international law. And then lastly is also transboundary wetlands resources management and looking at planning around them, specifically in light of climate change. What do we do if the one country or if the wetland shifts or secedes completely to another state, looking at those types of interactions in light of the Ramsar Convention. And I think with time, I'm doing good. So thank you. Oh, I also have to slide down to my references. These are my references, and thank you.
All right, thank you, Bramley. That was a very interesting and thought-provoking presentation. Let's go ahead and go to our Q&A. Again, I will be posing your questions and maybe a few of my own that I have received. Here, let me turn on my video. That I received through the Q&A button to the presenter. If you forget to ask a question or have to leave before the Q&A is over, you can email the presenter at the email address listed on the slide. So let's get started. So we have a question from Chema Hamana. Good evening. It's very interesting presentation. As a PhD working on wetlands in North Africa, specifically Algeria, I'd like to shed light on the modelization strategy. Have you already used it as a principal method to justify and improve your results? Do you agree that the modelization is a perfect method that you need to apply with all the environmental factors that affect those wetlands and ecosystems?
Okay. So is it question and answer? Or are you going to pose all the questions and then I'll answer? Sorry, Jason, just for clarity.
Oh no, go ahead. I'll ask the question.
Okay, cool.
You can go ahead.
So I've not used that method. It's actually the first time I've heard of it. So it will be interesting to share ideas around it, and also considering that Algeria is a party to the Ramsar Convention. So that will be an interesting model to look at if the person posing the question is able to share that with me. That would be fantastic. So the answer is no.
Okay. Chema also had another question. I think they had a couple of other questions. Have you focused on the priority zone areas depending on the heritage taxa in those ecosystems? I would like to know the simple and first step that can encourage governments for local conservation strategy and sustainable management. So I think what they're trying to ask is there a simple and first step that can encourage local governments on the path to conservation and sustainable management?
So again, if I have to think back on, well, it depends. So I can only speak from a South African perspective. If we focus or if local government, it depends on the powers that has been conferred upon the specific sphere, inherent and or regional powers and those delegated. So within a South African context, even though we have the regulatory framework, and at times our constitution is lauded for its efforts in bringing about not only change but giving effect to constitutional law, it doesn't mean that it is necessarily happening. So this study or the effect of the study is just to set out and say, look, this is your role in terms of the law. We need to see you do it. So that is my answer to that specific question. So it really, for me, it depends on the arrangement of the law and that specific legal system and how laws are implemented and how local government functions as an entity or an institution within that country.
All right. And then I actually had a quick question. So I guess you guest lecture at different universities, you lecture at your university, and you work with the Wetlands Forum, the Western Cape Wetlands Forum. Have you also worked with lawmakers or policymakers locally or in the state or national government in South Africa as well?
At this moment, not.
Okay.
Strangely enough, most of my work is with persons at government departments and researchers that's not researching law, because you try to tap into what do you need in science, because there has to be that integration. What do you need in science, so we can see if I can find it in law for you or arrange it or package it somehow so that I can have an answer. Also for our wetlands in Daba, it's predominantly the non-lawyers that's there. So whenever I come, I always feel that I'm the odd one out in terms of delivery. That's the work that I've done up to this point. One of the government officials has tried to tie me up with one of the policymakers at the national department. So we are regularly in contact. And we basically just share ideas, but the direct answer is no, but we're trying to get there. I'm hoping that even through these contributions, that it's something that one can think of. Also, Jason, you're cheating. You were supposed to ask me this last year in the USA.
Of course, I know I should have. Well, I think that
Okay.
covers all the questions we have listed. If anybody else has any other questions, I'm happy to answer those or ask those on here unless you have any further information that you'd like to provide.
I would like to also submit here that I know that it's a mixed group of persons, and those that's not necessarily going to the conference in Taiwan, I would also like to invite them. My email address is on this slide. I would also like to invite them to their or contribute their discipline in relation to the course or the teaching that I aim to. I see it as a project because in South Africa we do have some universities that teach water resources management, those, that, and the other, but not necessarily wetlands and the law, or aspects of wetlands and the law. So I'm really trying to build on that, but not only purely law. I can say with the inclusion of, with adding Prof. Aponte from Peru, that just added another level of excitement, not only for the student, but for understanding the package of wetlands resources management, because it's not only law, it's not only soil, it's not only, it adds other voices like gender studies, land use planning studies, etc., etc. So if please, I invite colleagues who's on this platform to please add your contribution, and I can chat to you in whichever other method we decide to post the initiation of the email. Thanks, Jason.
Absolutely. Well, I think that brings us to the end of the presentation. Thank you so much for volunteering to speak with us. I found it super interesting as an environmental professional myself who often works in environmental permitting here in the United States. I'm always interested to learn how wetlands are regulated and how laws are made and how these things are studied. It's very interesting. Definitely a very evolving field we're in.
Thank you so much. Thank you so much, colleagues, for joining us. Keep well. Bye-bye.
Thank you, Bramley.
Bye-bye.
All right. We are proud to recognize our SWS webinar series sponsors for 2024, Cattails Environmental, Davies Mitigation, and EcoBot. You can find their information at the websites listed above. Please visit, like, and follow our SWS webinar sponsors. Be sure to join us for our upcoming webinars. Our next two webinars are July 18th and August 15th, and the information on these will be released soon. Check out our website at sws.org and our social media channels to learn more and register for upcoming events. Don't forget to complete the survey that will be sent to you after this webinar to receive a certificate of participation and provide feedback on this webinar series. That's it, and have a great day, everyone.